So the explanatory notes you'll have at Authorities Bundle tab 5. The relevant part is at page 105, or the bit that you've not been taken to yet is at page 104.
104, yes.
You've been shown the relevant bit in respect of 169J. 1690, you'll see at paragraph 54, it tells you that section 1690 provides rules for determining what amount of the gain accruing in relation to a disposal of trust business assets qualifies for an entrepreneur's relief if another beneficiary, as well as the qualifying beneficiary, has an interest in the relevant settled property. It tells you that the amount is determined by reference to the qualifying beneficiary's proportional entitlement to the income of the relevant settled property. Then 55, subsection 1 of 1690 provides for the section to apply where there is at least one beneficiary besides the qualifying beneficiary who at the... Sorry.
Working on that.
Sorry.
Something went wrong. Please.
Sometimes old-fashioned paper works well.
This is what happens when you try and go paperless without being... Let's see if it can go away. I think it's Siri. Sorry, so we were in 55. So, but the point was, provides for, is that it focuses on the material time.
Yes.
And then 57, subsection 4, explains what is meant by the relevant proportion of the amount arrived at.
Yeah.
This is and again, it's that reference to the material time. By reference to the qualifying beneficiary's proportional entitlement at the material time, income part of the settled property that comprise the settled business assets disposed of. If at the material time the qualifying beneficiary is entitled to the whole of that income, no adjustment to the amount arrived at under section 1691 is required. But if the qualifying beneficiary is entitled to, say, 1/2, the relevant proportion would be 1/2 of the amount arrived at under section 169N1. And that addresses the point that we were discussing before lunch about where there's a change in the amount of the interest, of the individual's interest. The explanatory notes make clear that Parliament has chosen not the date of disposal, but the end of the 1-year qualifying period as being the material time. And so the assumption is that the qualifying beneficiary...
And it could be the date of disposal.
Could be, absolutely, it could be. But in circumstances where the condition in 4 provides that it's any 1-year period up to the end, it shows that the point at which Parliament is concerned about is not specifically the date of disposal. It is focusing at the end of that 1-year period, whenever that may be, and it is assuming...
And same question, any clue as to why?
Well, you'll see that what the upper tribunal say is that the only inference can be that Parliament intended there to be, for trustees to get, for trustee relief, for there to be a more enduring, longer link between the trust, or the interest in the trust, and the company.
You've got to do a bit of reading in to get that, though, haven't you? I mean, suppose the material time is, let us say, 1st of January 2022.
Yes.
And that's the end of a qualifying period of 1 year out of 3.
Yes.
That snapshot doesn't tell you for how long either the qualifying beneficiary or indeed the other beneficiary has held their beneficial interest.
With respect, it does. It tells, in respect of the qualifying beneficiary, it tells you that he has had that interest
tells you he had it on the 1st of January 2022.
Yes.
It doesn't tell you that he had it on the 31st of December 2021.
No, but it does tell you that he had it at that date, and that's consistent with an assumption that because it's looking at and the point of it being at the end of that 1 year period. In my submission, the inference must be that he had it through the
Why?
qualifying.
Why?
Because they've chosen the end of the why have the qualifying period at all? They've chosen it by reference to the end of that qualifying period.
It looks to me at the moment as though, the primary focus is just fixing, in the interest presumably of certainty and simplicity, on one particular day.
Yes.
So that means we all know what day we have to do the snapshot on, and it's the end of that 1 year period.
But it's not the date of disposal.
Well, it may be.
But it's not.
It could be anything up to 3 years earlier
Exactly.
than the date
Exactly.
of disposal, if I got
Exactly.
my arithmetic right.
But if my learned friend is right, but it is only concerned with you having an interest in possession at the date of disposal, you wouldn't have any reference to subsection 4 and the qualifying period. It would simply be that by reference to, if there is more than one person who has a beneficial interest at the date of disposal, it is apportioned by reference to their respective interests at the date of disposal. It would be very simple. You could deal with it in one paragraph. There'd be no need to look at the 1 year qualifying period.
So I've got an interest in a settlement, and my interest in the settlement was 100% interest at the material time.
Yes.
I would like to benefit my children, so I give them half my beneficial interest.
Yes.
So at the date of disposal, I only have 50%.
Yes.
There's no need to make any reduction in the relief.
It's 100%. Yes. That's what the section says. And that's the date that Parliament has looked at.
Yeah.
But that selection of a snapshot date doesn't actually have any connection to the period of time that the qualifying beneficiary may have been connected with the company.
Well, it has a connection with
But it just comes at the end of a
of a 1 year
period.
Yes.
But it tells you nothing about the connection otherwise. There has to be a 1 year connection for you to be a qualifying beneficiary.
But with respect, so there has to be the 1 year period where both sides are agreed. A 1 year period where at the minimum you have to have satisfy the personal company, should we call it,
Yes.
provisions.
Yes.
This assumes that at least at the end of that point, you have an interest in possession. And in my submission, by reference to,
But you don't need to have had it the day before, and you don't need to have it the day after.
well, in my submission, you do have to have had it the day before. You have to have had it for the whole of that period. And what it is looking at, it is doing it. Could I just finish this? Just one point. What it is doing though is the reason you are looking at the end of that period is because at that point you are looking to apportion as between somebody else with an interest, and you're looking at because your 1 years might be different years, but what you're looking at is at the end of your 1 year. So if I'm the qualifying beneficiary, you're looking at the end of that year. Is there somebody else who has a interest in possession? And then you're looking at our respective proportions at that date.
But the other person doesn't have to be similarly a qualifying beneficiary at all. It just has to be a beneficiary.
Yes, that is right.
And there's no requirement for the interest under the trust to continue, as it's just been pointed out,
Well, to continue in the same
until the date of disposal.
in the same amount, yes.
Yeah.
Because
I'm still baffled by the concept, I'm afraid to say.
As to that, as to why, or as to that is the result.
Well, as to why,
On it.
actually.
Sorry, I don't know why it's doing that.
As to why, just trying to understand what purpose Parliament had when...
I won't respond to that.
Well, that's one way of dealing with my lord's questions. What's this? Alexa, tell me the answer.
Siri, yeah, right. Siri is.
Excellent.
Sorry. It's not done that before. There we go. Sorry,
I'll take the hint. No.
No, but sorry, my lord. I think one. The problem is that there isn't an explanatory note or a consultation that tells you why this is what Parliament has chosen.
No.
But I think what is common ground is, well, what is clear on the face of the explanatory note and the face of the statutory provision is that is what Parliament has chosen.
But what you are trying to do is to get us to use what you say is the meaning of that provision.
Yes.
Section O.
Yes.
And use that to interpret the earlier section, which actually sets out the entitlement, if I can put it that way, as opposed to the proportion, setting the proportion. And to understand why, I understand entirely you say they should be looked at together,
Yes.
but I'm trying to understand what relevance the job that is being done by Section O has to the job which is being done by Section
J4, but J4. J4, yes. And my answer to that is that O is not concerned with, is not looking at sort of Section 169J in total. It's specifically linking it to and working on the basis of subsection 4.
Yeah.
It fastens upon that 1 year period, and in my submission it informs, I could put it no higher than that, it informs when you have two competing constructions as to 169J 4, the fact that our construction is consistent with 169 that informs or suggests that our construction is the correct one.
Yeah. No, I think we understand how you put it. We're still a bit puzzled about why, but I don't think you can really help us on that.
No.
But you say that's what it says.
Yeah, well quite.
And to that extent, I think you would agree with Mr. Firth that the only purpose you can discern comes from the words that Parliament's used.
And that's. But I think that can be said about both parties' arguments, because both parties say, well, they're both deriving the purpose from the words.
Yes, right.
Yeah.
And so we say the words show this purpose, they say the words show their purpose.
Well, there we are. That's for us to decide.
What is perhaps surprising at first blush is that this legislation has been around in substantially similar form since 1985, albeit with a gap in the early 2000s. And, personal companies are far from being uncommon. Entrepreneur relief is something you imagine is being claimed every day of the week by lots of people. So it's rather astonishing that these points don't seem to have surfaced.
But
and equally, perhaps surprising that somewhere in the depths of Somerset House there isn't some reference to actually what the thinking was behind these extraordinary provisions. But
I'm not sure if there's...
if there were, it wouldn't be admissible, probably. I mean, that doesn't stop people trying
quite
to put
possibly. Also, the rats have probably got to it in Somerset House. But
all right.
But my Lord, can I though address you on that point that my Lord Justice Snowden has said? Well, why? Well, of course, one of the points that Melonifrin hasn't grappled with, and that troubled the upper tribunal, was that if he is right, and it is solely concerned with at the time of you having an interest in possession at the time of disposal, on the day of disposal, you could bring yourself within these provisions by transferring it to an individual who satisfies who has the personal company conditions in 4A and 4A A and B. You could give them an interest in possession at the date of dismissal, and then they would get the benefit of this. You get the benefit of this relief. The trustees could get the benefit of this relief.
That would be the case if instead of giving the entrepreneur, let's call him for short, an interest in possession, you gave him the shares. He'd get relief. So it was a disposal by an individual. He'd get the relief, wouldn't he?
But the trustee.
No, trustees wouldn't, but he would.
Yeah. But this is about the trustees getting the relief.
Yes.
Yeah.
But the underlying rationale. Sorry.
So you've got trustees who hold some shares. There is an entrepreneur.
Yeah.
Trustees have two choices. They can give him an interest in possession, or they can give him the shares.
But if they give him the shares, that's a disposal at market value.
You could hold over there, couldn't you? Any gain?
Don't.
No. It's business property.
So no, then it would be so you could. I think my instructions are you could achieve that result in that way.
You could.
Yes.
I thought so.
Is one of your lordships controlling it?
I think Mr. Firth maybe.
I mean, the point there, of course, would be that the individual would own the shares.
Yeah.
So it's quite a big step.
It is, but this all brings us back to the point that, I mean, as it were, the underlying substantial qualification that has to be satisfied either way is having the necessary connection with the company, for a sufficient 1 year period or more. And if that is satisfied, then in the case of individuals, there's no minimum period of ownership at all. So plainly, Parliament is contemplating the possibility of last-minute transfers or acquisitions with equanimity, provided that the substantial connection with the person or company test is satisfied. So why should it be any different when we're looking at the trustee extension?
So, first of all, Parliament has not chosen the same conditions in terms of you've got the not looking at the 1 year up to the date of disposal.
The period is different, and that may owe its origin in some mysterious point to do with retirement. I mean, we don't know why, but there it is.
Yeah.
But that apart.
Yes, but also, but that apart, you've got, and perhaps now is the time to. Can I just show you 59 and then go to section to J?
So are we looking at?
We're in the explanatory notes.
Yes.
Yeah.
105, subsection 15. So subsection 6 explains what is meant in subsection 4 by the material time. In the case where the settlement of business assets disposed of are shares or securities, the material time is the end of the latest period of 1 year, ending within the period of 3 years before the date of disposal, throughout which the conditions in section 169J4 are met. So it's taking you back to, it's linking you back to section 169J4.
And this is really just all paraphrase of what one can read in the legislation itself, isn't it? And that's one of the problems with these explanatory notes. And can you remind me who they're drafted by? They're not drafted by the parliamentary draftsman, are they? They're just departmental input.
Yeah, the sponsoring department.
Yeah, sponsoring department, yes.
But they are, yes. Let's say, but of course they are a permissible aid to construction.
Yeah, sure.
But the weight that and what they tell you depends on what they say.
Yes.
And so often they are, as I say. I mean, I'm not seeking to belittle them, but they are usually just a paraphrase.
Yeah. Sometimes, well, it may well be this isn't such a case, but there are some cases where they do illuminate the.
Well, I think if we look at the passage we've been taken to before in paragraph 124, I mean, that does make the positive point that the there is a deliberate carryover from the previous retirement
Yes.
relief provisions where the language is similar.
Yes. So then can I take you to 169H, please, which is at page,
16.
yes. So this is just simply the point about when you look at the introduction section, that sets out your code. So the suggestion that you can't look at, or that O is an obscure part of a different act, or you see in sub 5, it gives you.
Yeah.
Yeah, absolutely. I mean, it's an integral part of this particular code.
Yes.
And the fact it's a self-contained code all on its own is reinforced by the point that the provision that anything that's charged under this mini code doesn't count for the purposes of, doesn't count as a disposal for any other purposes.
And so then if one looks at J, which is at.
Although, what was first said is, look at subsection, say, 169H, subsection 4 and 6. Sorry, 4 and 5, I'm sorry.
Yes.
Sorry, can I just see if I can switch this off? Sorry, I'm very sorry.
Would it be helpful?
Although probably not quite as entertaining.
I mean, it may say, who's asking you stupid questions? Are they quite embarrassing?
Good. I think I've managed to. I think I've managed to turn off. Apologies. Mr. Firth said.
Subsection 4 says this is the provision, makes provision requiring the making of a claim for entrepreneur's relief. Subsection 5 says makes provision as to the amount of entrepreneur's relief.
Yeah.
It having been, why do you find in something which is billed as a provision simply as to the amount, something which you say is important to understanding the substance of whether the relief is available?
So, and actually 4 and 5.
I mean, I understand you made the point that it may give a clue to what the draftsman had in their mind, but it's not exactly well signposted for the reader who is intended to be signposted through this.
But in my submission, that's actually why 4 and 5 are quite good as a contrast, because 4 is talking about the mechanics of how you make a claim. That point might well apply to the mechanics of how you apply. But in terms of the amount of the relief, that's an integral part of the relief.
But you're not I mean, you're not perhaps I should have gone to 2. I mean, you're not given a clue that part of the concept of a qualifying business disposal, as identified in sub 2, is actually hidden away, or that you need to look at 5 in order to understand what is.
Well, I certainly accept that it's not there, but in my submission, that does, as in it doesn't say that in 2, but in my submission, in circumstances where this provision is part of this code, this mini code.
Well, I think we all agree that you must read them together.
Yes.
But I think the point that's being put to you is that if O qualifies what is a introduces another condition to be satisfied
Sorry, that's not
before
my case.
there is a qualifying business disposal, you would expect subsection 2b to say disposal of trust business assets. See section 196J and 196O.
It's not my submission that O qualifies. It simply informs.
Right.
It simply demonstrates why our construction of section of J is correct. Sorry, I'm not for one moment sort of suggest that O qualifies it.
Right.
Or that's where you find the condition.
Yeah.
It simply indicates, demonstrates that our construction is the correct construction.
Right.
And it's consistent with our construction and not with Mr. Firth's.
Yes.
And that's what the upper tribunal found. The upper tribunal didn't find that O added a condition. It was simply that O made clear that the revenues construction was the correct one.
Right.
So then I was going to go to J.
Yep.
So this then really starting with 3, which is what does 3 do? And the starting point is that 3 is not the definition of a qualifying beneficiary. It's not looking at any particular point in time. It tells you when you are a qualifying beneficiary, and you are a qualifying beneficiary at all times when you have an interest in possession. And that definition that defines when you are a qualifying beneficiary. So then when you look at 4 and you read the qualifying beneficiary, that is someone who has an interest in possession. And
that can be under a settlement which does not include any of the business assets subsequently disposed of. In other words, under A, 3A,
yes,
if you have under the settlement an interest in possession of the whole of the settled property, it doesn't need to include the settlement business assets disposed of at that time.
No. So it must consist of include the shares disposed of.
Not if it's the whole of the settled property.
Yeah, but we say that's implicit in A. The whole of the settled property, and so it will include the shares in that example.
Well, surely, if that was what it was meant, it would have said the whole or that part of the settled property which consists of or includes, etc. Sorry, bracket, comma, which consists of or includes. It's surely you would link. If what you're saying is that the whole must necessarily include the settlement business assets, surely you wouldn't have drafted it that way. You would have made that the overriding requirement for the whole or part, i.e. that the settlement business assets disposed of should have formed part of the settled property at whatever the relevant time is.
Well,
I mean,
it could have been, but we say that that's how.
And the premise of the entire section is that there's a disposal of settlement business assets. Isn't it? So surely the whole of the settled property has got to include them.
So if you own the whole,
yes,
then that's covered. But if you don't own the whole,
then you
must own the part. Yes,
the relevant part. Yeah.
We've skipped over subsection 1,
yes,
which is drafted in the present tense.
yes,
Subsection 1b, which says there is an individual who's a qualifying beneficiary.
yes,
That must be at the date of the disposal.
yes. But and so you apply the definition in 3, an individual is so you say at the point in time of the disposal, the individual must have an interest in possession.
Yeah.
So so that you look at that, and then on 4, in our submission, when you see the qualifying beneficiary, you again apply the same. You say, is it does a person who has an interest in possession? And we agree that there has to be a reference to a specific person, because the requirement is that that person must meet both the conditions in A and B. It's not sufficient that you have a qualifying. You may have more than one potential qualifying beneficiary, but it's not sufficient. Say if you have two qualifying beneficiaries, it's not sufficient that Mr. A satisfies A sub 4A, and Mr. B satisfies 4B. You're concerned with
They're cumulative.
exactly,
conditions.
and that's why there's a reference to the rather than A.
Well, I mean, yes, but so far this all seems to rather feed into what Mr. Firth was submitting to us, that the focus is precisely on the date of disposal and the relevant connections being established, A, with the company, B, with the trust.
But with respect, you're looking at that individual.
So you as I understand it, you say you must repeat the definition when you get to 4.
Yes.
So you read 4 as saying, throughout the period of 1 year,
Yes.
the company is the personal company of an individual who has an interest in possession. That's the way you want to read it. So throughout the year, he has an interest in possession.
He has an interest in possession. It's his personal company,
Yeah.
and the company is a trading company or the holding company of a
Yeah.
trading group. So that 4A, it's not just there are different parts to 4A that you've got to get through.
No, I understand that.
And-
I'm just trying to slot the definition
Oh, absolutely.
to
Sorry.
try and see how your
Yes.
linguistic argument works, and I think that's how it works.
Yes.
You have to reorder the words a bit to make it grammatical, but it's the personal company of throughout the period of a year, the company is the personal company of a person who has a beneficial interest.
Exactly. Effectively, the words in sub 3.
Yeah.
And that's all we're saying is that 3 gives you the defined term, and that is the term that's used in A and B. I've explained why it says the rather than a qualifying beneficiary. And as I
Yeah.
say,
Yeah.
if there isn't a need for the definition, if Mr. Firth is correct, you don't need the definition. You can just say the individual, and you certainly don't need to repeat it or refer to the capacity in A and B. You simply say the individual is
Yeah,
the company is the individual's personal company.
It depends how you apply this. I mean, you might ask, well, is Mr. Skinner a qualifying beneficiary? Answer, yes, because he had an interest in possession at the date of the disposal.
But
And then you ask,
individual
well, was
being,
the company Mr. Skinner's personal company? Answer, yes.
yeah.
So that's the way Mr. Firth reads it. You've identified the individual in 3, and then you ask
Yeah.
whether the company is the personal company of that that identified individual.
But with respect, if that is all it was, then that's why you would only. That's why you don't need to refer to
Yeah.
the qualifying beneficiary. You just say the individual.
But that brings on back to the way in which the draftsman in the modern world does these things. You define a term and you then use it in a very sort of algebraic kind of way, as I was suggesting earlier, in the interest apparently of simplicity and making it all easier for people to understand.
But within this context, though, with respect, surely just simplicity would have been the individual.
Well, I'm not sure, because having gone out of the way to introduce a definition of the qualifying beneficiary, who is ex hypothesi an individual, then it's more natural to use the defined term once you've done it,
Well-
once you've made the definition, isn't it?
With respect, not because when one looks on my learned friend's argument, 3 is only in relation to 1b. There is an individual who is a qualifying beneficiary. So you could even, why do you even need 3? You just say, if the only relevance is that there is an individual who has an interest in possession at the date of disposal, that could all be put in 1b. You don't need 3.
But the label is apparent from subsection 6 as well, isn't it? The use of the label. I mean, reference to a business carried on by the qualifying beneficiary includes a business carried on by a partnership of which the qualifying beneficiary is a member. I mean, why don't they just say of which he is a member or they are a member? I mean, it's just using, Mr. Firth says it's just using that defined term everywhere you want to refer to the person in a very clunky way. But
it's a very odd way of if that is all it is doing, you don't need the defined term. It's the individual. The individual. If all it is, if the only relevance of the interest in possession is that at the date of disposal, at the date of the disposal of the business assets, there is an individual who has an interest in possession. You put that in 1b, and then you just talk about the individual. You don't need the definition, the defined term. That, in my submission, that.
I mean, arguments about how you would express it much more simply and snappily, in a sense, just take one back to how it was originally drafted in 1985, which is a good example of the way parliamentary draftsmen used to operate, which for most of us is probably a rather more familiar and sometimes even, dare I say it, helpful way of doing it.
But with respect, one still has to make sense of why Parliament, if all the relevance of the interest in possession is that at the date of disposal there was an individual that had and it was irrelevant that you had an interest in possession at an earlier date, at any other date, any earlier date. In my submission, there is no need for 3, and there is no need for the definition. It makes no sense. So it's not just about, it's a way of making it simple. In my submission, it does the converse. If that's what's the purpose is.
Yeah.
Whereas our construction gives sense or makes sense, gives a purpose to the use of that defining the term and then using the defined term in subsection 4.
Yeah.
And then that's where O becomes relevant, because O supports that construction.
Yes.
And that's, in answer to my Lord Justice Snowden's question, that's my reliance on O. I'm not saying that O imports that condition. I'm saying that condition is there already. That it is there already is reflected in the way Parliament has chosen to deal with apportionment.
Yeah.
Can I just check if there's anything further on that point? That then takes us to 1690. I should, given my learned friend relies on it, I should deal with 169M, which is at 30, page 30. Where he says this is being used here, but in my respectful submission, this is just a shorthand, simple provision, and it's obvious that that is referring back to the main provision, and it's not inconsistent with our construction.
Mm-hmm. Yeah.
Then you get to O.
Right. We have already discussed O in quite some detail.
Yes, and I'm not sure. Sorry. Well, unless your lordships wanted me to go back through O, I think you have.
Well, if there are new points on it, then make them.
No, I think I've got out of O, or I've sought to get out of O at least.
Right.
You have our submissions.
Yes.
So can I then go to the upper tribunal's decision? I don't think there's anything else in these provisions that I need to take you to.
Yeah. So you say the upper tribunal was right for the reasons they gave.
Yes. I mean, essentially, it's a very detailed decision. My lords, you've read it.
Yes. If there are any particular points you want to highlight, then obviously do.
Well, no. I wouldn't say particular points because they've gone through it very meticulously. I adopt all of the points that they have done, but largely it's based on the interaction, the construction of 169J, supported by 16 and then confirmed by 169O.
Yeah.
So, my lords, is there anything that you wanted me to address you on that I've not addressed you on?
Well, the only part you might, I suppose, want to elaborate on is what the upper tribunal said about the policy behind the relief, paragraphs 88 and following. I mean, I'm not sure that I discern from what they say that they did reach any very clear view about what the policy was.
Well, I think the key provision there, I think, is, well, the key point is that in 98 they identify the connections,
Yes.
the meaningful links, the trust, the beneficiary's trust while the beneficiary is working in the business, and the disposal of the shares in the company. But in many ways, I say this is all, it might be said to be a bit circular at both sides, in the sense that both sides, the purpose that either side derive
Comes out of the words.
comes out of the words. And so essentially the FDT say identify the same purpose as my own friend, and they do that by looking at 169J. The upper tribunal say, well, no, when you look at 169J in context, both starting with the textual analysis, then looking at the other provisions, the purpose requires more than a more enduring link.
Right.
And so I think, in fairness, it's just simply a consequence. The
Of the
purpose
construction.
of the construction. So, sorry.
No, I'm going to say, so what we need to be aware of course, is trying to conjure out of nowhere a formulation of the purpose, which then begs the question in favour of one construction rather than the other.
Yeah, but
I mean, we're left just with the,
yes,
as it were, the classic situation of having to make the best of the language Parliament has used, on the assumption that they were intending to achieve a rational outcome.
and in fairness, that's the criticism the upper tribunal make of the FTT, is that the FTT start with the purpose. The purpose is simply to extend, therefore this must be the reason. And what the upper tribunal say is, well, that assumes what you have to
Demonstrate.
demonstrate, and
Yes.
and what the upper tribunal do is they say, well, and that's, you see, the upper tribunal deal with purpose last. They first deal with the textual analysis, look at the context, both the historical and the wider context.
Yes.
That they think is the correct construction, and then they move on to the purpose, and they say that is consistent with the construction.
I think perhaps the upper tribunal were being a little unfair to the FTT at that point, because, I mean, given we do have to construe this as a self-contained code, adopting Mr. Firth's approach, we open it at page 1 and we see 169H giving a very clear program of what is going to follow. Then we see 169I dealing with the, as it were, the plain vanilla case of an individual making a transfer. Certain conditions have to be satisfied. in subsection, is it 4 or 6, I forget which, we see the two twin conditions relating to the entrepreneurship condition, which have to be satisfied. Then we turn over the page and get to or maybe several pages down, to 169J, which is the trust add-on.
Yes.
And then we see, again, in terms of structure, on almost the first approach, a very logical-looking way of dealing with it, which is to posit, first of all, a necessary connection between the beneficiary and the trust, and then a necessary connection between the beneficiary and the company, followed by the further condition which has to be satisfied, which is then set out in terms which take one back to the previous section.
But with respect, when you then get to the third, though,
Yeah.
the third condition, it all turns then on who that connection is between.
Yes, but by that stage we already have gone through the first two stages and taken on board a definition of qualifying beneficiary, which is tied, as you accept, to the date of disposal.
No, with respect, I don't accept that the definition of a qualifying beneficiary is tied to the date of
No, you
disposal.
say
I beg your pardon.
you say it's a roving definition.
It's a roving definition, although but when it's first introduced, it's only referring to the date of disposal. Isn't that
Well,
right?
well, with respect, it's when one says it's first introduced, if we go
In subsection 1.
In subsection, yes.
all 1B is doing, it's not saying that's the only relevant time. It's simply saying it's setting out a number of conditions. The first is which there must be a disposal.
Yeah.
The second is which is at that time there must be a qualifying beneficiary. It says nothing at that point. There is nothing to say that there is no additional condition that there must have been earlier.
Yes. Right.
And so that's all, and so the temporal part of 1B isn't part of the definition of a qualifying beneficiary. It's simply saying there must be a qualifying beneficiary at that point. 3 is the definition of a qualifying beneficiary, which is not temporal. It's not saying at any particular time. It's simply saying a qualifying beneficiary is someone with an interest in possession.
Yeah.
And then, and it is defining that term. So, and it's that capacity that is then used in 4.
Yeah, and that's your gateway into your
Exactly.
reading in 4.
Exactly.
Yeah. All right. Is there anything else you want to share us in the UT decision?
No, the only thing I was going to say actually was my Lord, just really addressing the judge's point about, Lord Justice Henderson's point about being unfair to the FTT. The other point that the upper tribunal rely on is, of course, that it's not simply a transposition from individual trustee, because, of course, the trustees are different. And this is the upper tribunal deal with, is the differences because it is the trustee that gets the benefit. And so it's not just a simple transposition. And so there are differences.
Perhaps reinforced by the fact that for CGT purposes, trustees are regarded as a separate person in their own right.
And with respect, that is all dealt with in the upper tribunal's decision.
Yes, that's very clear and very helpful, I think, the way they take
Exactly.
onto the architecture of CGT, which is part of the general background.
And again, that's why I say that they have approached it in the correct way, looking at the content, not just focusing on the words, looking at that broader permissible context, important context. And you see that, I think is it immediately after, or I think it's just after. Sorry, so they've got, yes, it's 48. Is that sort of summary.
Yes.
And these are all differences. Can I just check if there's Unless there's anything else that I can assist your lordships with.
Thank you very much. Mr. Firth, do you wish to reply?
If I may, my lord, as an introductory point, I attempted to send over the lunch to 3 settlements plus the...
Yes, I think my clerk received them.
Thank you, I'm grateful for that indication. I think I have 10 short points, if I may. The first point is on the start of legislating. I think the court has this point. It's adopted and rewrite legislation, but it's also visible in this legislation. And that's what you'd expect, given it was written around the same time. And it's simply that it's intended to be logical, easy to understand, and signposted where possible. That point was not about saying, do not look at section 169.0. And that's my second point. I'm not saying you shouldn't look at 169.0. Instead, I'm making 2 points. First is looking at it doesn't help you. And the second is, it would be very surprising, as the FTT thought, if Parliament had expressed itself so obliquely in the actual provision dealing with conditions for relief, that we had to infer the existence of a fundamental further condition from apportionment provisions.
Yeah, I think you made this point in opening.
The third point is that 1690 is not the only other provision that deals with trustee relief. 169M does, and HMRC agreed that doesn't import the definition when it refers to the qualifying beneficiary.
Yeah.
My fourth point is that section 169J does not, in my submission, have 2 meanings. HMRC are reading in words that are not there. And that goes back to the points I made this morning.
So when you say it doesn't have 2 meanings, you mean it's not ambiguous. I obviously
Exactly.
can't have 2 different meanings simultaneously.
He accepts it's got 2 meanings, as if that's some sort of common ground, but we don't accept that. We say, you look at it, it has 1 meaning, which is our meaning, for the reasons I gave this morning.
Sorry, I can't have 2 meanings simultaneously. It's just, but there could be a choice of possible meanings, in which case his argument is, for all the reasons he's developed, we should go down his line rather than yours.
I think what he meant was it's capable of being read in more than one
It's
way.
badly expressed, and my order's right.
Yeah.
But I think the court has the point anyway. But my learner friend waited until the very end to take you till 169J, despite it being the critical provision. He didn't even start at the beginning of 169J. He started at subsection 3. And the problem with that is you lose the logical structure, because if you start at 1, as I showed you this morning, it has signposts. So for 1A, it refers you to subsection 2. For 1B, it refers you to subsection 3, the definition. And then for C, it refers you to 4 and 5.
Yeah.
And then my learner friend just did not deal with the fact that there is no cross-reference or signpost in C or 4 telling you to go to 3. Whereas on his case, that's fundamental. You definitely need to do that. And that's a big omission that my learner friend just didn't deal with. My learner friend also didn't deal with the question I posited both in my skeleton and this morning, which is on his approach, if you are a qualifying beneficiary at the time of disposal, but you don't satisfy the tests in 4 and 5, are you the qualifying beneficiary? Sorry, if you're a qualifying beneficiary at the time of disposal, but not at the earlier times, are you the qualifying beneficiary? And the answer to that in my submission must be yes, because who else do we apply the conditions in 4 and 5 to?
Well, I think on his reading, you would be the qualifying beneficiary, but you wouldn't have satisfied the personal company condition.
So even though, so you are the qualifying beneficiary, even though you don't satisfy even though you didn't have an interest in possession.
No, you had an interest in possession.
So, sorry.
At the date of the disposal,
Yes.
but you couldn't satisfy the condition in 4 on his reading, because you couldn't satisfy the company is the personal company of a person. Throughout the year, the company is personal company of a person who has qualifying interest.
But if we look at the exact wording of subsection 4,
Yeah.
it says, so it applies a test to the qualifying beneficiary. If you don't have an interest in possession during this time, my submission is you're still the qualifying beneficiary because it's the date of disposal. My little friend's submission, well, I wasn't clear. Is he saying that, no, you're not the qualifying beneficiary because you didn't have an interest in possession? In which case, who do we apply the test for to? Or is he saying, yes, you are the qualifying beneficiary, but you fail condition 4? But how can that be right, given that his whole way of trying to get meaning into 4 is through the reference to the qualifying beneficiary? And in terms of my learner friend's submissions on, well, if I'm right, they needn't have separated out the meaning, the definition of qualifying beneficiary into subsection 3. Well, they didn't previously. And in any event, if you refer back to Derry, paragraph 8, it says that one of the features of modern drafting is to unpack dense legislation. This is simply an example of unpacking dense legislation, as it does with each of the other conditions. So for each of A, B, and C in subsection 1, it cross-refers you to something else that, in theory, you could have incorporated into 1, but it doesn't. My 5th point is in respect of HMRC's submission that you have to own the shares. Sorry, the trust has to own the shares disposed of in order to satisfy the definition of a qualifying beneficiary. And that goes further than what they told the upper tribunal. They told the upper tribunal you needed to own 1 share. Now they come, and I understand it, they say you have to own all the shares. And that's a really big additional condition that we see nowhere in the legislation. And the only reason we're reading it in is because of the problems created by requiring this test to be applied at a time other than disposal. We don't do that. We don't need to read in additional words about owning shares. And when we try to unpack the consequences of this new interpretation requiring all the shares to be owned, we get to some fairly difficult questions as to A, why, and what happens. So if you own 50 shares and there's a share split or new classes are added or you acquire more shares, if you don't own every single share throughout that 1-year period, does that mean you fail the test? Because the shares disposed of, let's say, are 100 shares. If I own 50 shares throughout, sorry, the trust owned 50 shares throughout the relevant period, the 1-year period, then the shares disposed of are 100. Let's say they're 2 different classes. I did not have an interest in 100 shares throughout that 1-year period. On HMRC's new case, it's 0 relief, apparently. So, I mean, these are the imponderable questions that we sort of touched on with Lord Justice Henderson this morning. If you start asking the trust to own shares...
Well, I think you accepted that, didn't you? If a trust own all the yes, if a trust own all the shares, there's no personal company of the qualifying beneficiary.
Sorry, when I say all the shares, I mean all the shares ultimately disposed of.
Right.
My lord is right, that's a separate problem. That if the trust owns all the shares, it can't be your personal company. But this is the point here is to distinguish the situation where the trust owns 50 shares during the 1-year period. It acquires 25 more shares and disposes of 75 shares.
Right, yeah.
You haven't had an interest in possession of all the shares disposed of. Section 1690 does not assume that the qualifying beneficiary will have an interest in possession at the end of the 1-year period. There is no difficulty here. If the qualifying beneficiary does not, but someone else does, you get no relief. And in fact, HMRC say this. Paragraph 41 of their skeleton argument. They say the effect of section 169.0 is not simply to apportion chargeable gains, but to restrict relief, potentially reducing it to 0. That can only be right if you have no interest in possession of material. So there is no assumption. Point 7, the material time. Section 169.0 does not demonstrate any conceptual thinking about this apportionment or how it should operate.
Sorry, can you just repeat that sentence?
Does not demonstrate any conceptual thinking about how this relief or apportionment should operate. And I sought to demonstrate that this morning by reference to...
So when you say it doesn't demonstrate any conceptual thinking,
So
thinking by who? Or, sorry.
Well, sometimes you can look at a piece of legislation and say, we see what you're trying to do there. You've got some underlying theory of how this should work, and you've tried to implement it. And that may assist you in dealing with difficult cases. Here, there is no underlying concept that you can have any resort to. It's sort of the point that was made a few moments ago, that we're really just left with the words. So to try and derive some more fundamental meaning from, for example, the reference to material time and why the material time was chosen.
So you're just saying that the words of O don't actually tell you what Parliament was thinking?
Any more than simply the black and white text of what it actually says, yes. There's no underlying purpose to be derived from those words. It's just, this is how it operates. It's very mechanical. And I sought to illustrate that this morning by reference to the 10% interest in the income versus the 90% discretionary income. You get 100% relief.
Mm.
And my learned friend didn't deal with that, probably can't explain that. But that shows, but that shows that an attempt to try and link this relief in some way to the quantum of your interest in the income is doomed to failure, because that's not how it works. Indeed, the most I've been able to wonder about this is whether it's about portioning relief between interest in possession beneficiaries, because that's when it bites. It bites when you've got two interest in possession beneficiaries. And it might be about trying to divide up the using up of their lifetime allowance. Because how else do you explain the fact that if I have a 10% interest, if I have a 10% interest and there's another beneficiary with a 10% interest, it's split 50-50. You still got relief on the 100%. If I have a 10% interest and nobody else has an interest, it's just 90%, I get 100%. So if you're trying to think of some possible rational explanation for why this looks only at that situation, isn't concerned about discretionary income, that's the best I can do. But applying section 1690 to cases of two beneficiaries is very, very difficult.
Yeah.
I suppose, the minimum one can say is it is in some sense meant to be an apportionment provision, which is going to reduce the amount of relief you get in a situation where there is another beneficiary which satisfies a particular test of a not dissimilar looking nature. But if that is the underlying intention, it's hard to formulate a coherent description of it which doesn't give rise to anomalies.
Exactly.
Whichever side is right.
I agree with that, my lord. And that's why the emphasis my learned friend sought to place on the material data and why we're looking back. Well, he couldn't explain why we're looking back. He just said, well, we are looking back. That assumes there must have been an interest for the qualifying beneficiary at the time. My answer to that is no. If there's no interest at that time, then you get no relief on where 1690 applies. And you've seen the HMRC skeleton, they say potentially zero relief. And as my Lord Justice Snowden observed, well, actually, the material data could well be, and may well often be, the data disposal, in which case there's no difference. My eighth point is about the suggestion of manipulation. And the point made against me here as well, if it's all about the data disposal, then you can just manipulate interest on the data disposal, and that's why possibly Parliament's chosen a different data, material data, but it doesn't solve the problem. If you can manipulate on the data disposal, you can manipulate on the material data. You haven't solved the problem of manipulation. And in fact, there's no need to manipulate if no one else has an interest in the income. It's discretionary. And as the court noted, you can just transfer to a beneficiary, hold over the gain, and they can qualify for it.
Yep.
My ninth point is that my submission that this is an extension of the individual relief is supported by essentially the path of reasoning Lord Justice Henderson repeated or set out before, which is when you follow it through, start with 169I, you see the conditions, and then you go to 169J, and you've got essentially the same conditions. And my learner friend said, oh, well, you've got this 3-year period in J, but not in I. But what he was overlooking there with respect was condition B, which I showed you this morning in 169I subsection 7, which is the 3-year period. That was the point that where if the company ceases trading or you cease to be an employee within a 3-year period before the date of disposal, you can still qualify for relief under 169I subsection 7. My final point is on the previous legislation. Our position before the upper tribunal, as you'll see before the from this post-hearing submissions, was that we shouldn't be looking at this. But if we did, it helped us for the reasons I set out this morning. We stand by that position. It's very dangerous to be looking at legislation that's not been, is not a direct successor and is only based on a broad understanding of previous legislation. We need to open the question, well, where has it ranged wider or narrower or differently? If this was a direct rewrite, we still wouldn't look at it, because as you saw in Derry, the whole point of rewrite is to avoid this resort to previous legislation because of the problems that we've seen it give rise to. But if we did look at it, my submission, as I said, submitted this morning, section 70, subsection 3, is very clear that qualifying beneficiaries are labelled. And it seemed that my learner friend was suggesting this morning, before lunch, that actually in section 70, subsection 3, what was relevant was whether you were a qualifying beneficiary at the earlier time, but not at the time of disposal. But certainly accept in relation to this legislation that you need to be a qualifying beneficiary at the time of disposal. My lords, if I may just turn my back for one moment. My lords, you have, as I said, our step-by-step response to the upper tribunal decision in the skeleton. I haven't gone through it slavishly, but overall I hope I've dealt with the key points, and unless you have any further questions, that's the reply.
Thank you very much, Mr. Firth.
Thank you.
Well, I think we all agree this legislation's a bit of a puzzle, so we will reserve our judgment. You will get a draft in the usual way, which will be your opportunity to correct our English, but not our reasoning. The draft judgment comes, I should say, with a beefed up embargo, which means what it says. We would hope that in the light of the draft judgment you will be able to agree an order disposing of the appeal. But if you can't agree a form of order, please make short submissions, and we will make the form of order that we consider to be appropriate.
Thank you, my lord.
Thank you very much.